to his office. These judges were taken to the DCI to record a statement. And the most interesting thing is that Justice Chitembwe says there was no such, the arrest warrant or even the search for documents to show that these police officers were given the right to actually go to their offices and search for what they were looking for. And even when they went to the DCI, they were not even told why they, why they had gone there to record a statement. It was just being questioned about what transpired in the course of the day at around 1:30 when the police officers got into the office of Justice Muchelule.
Thank you, Brenda. I think two things need to be addressed. Number one, the DPP's statement must be understood in its proper context. The DPP said he is not aware. I think the DPP was responding to a section of comments made by, I think, LSK Nairobi branch chairman, attributed to LSK Nairobi branch chairman, who dragged the DPP's name into the conversation around the arrest of the judges. He said, I'm not aware of that arrest. Now, it is not a legal requirement that investigations and arrests be preceded by permission by the DPP. The DCI performing their functions, they do so independently. But Section 35 of the National Police Service Act permits the DPP to direct the Inspector General of Police to conduct investigation in respect of a matter that has been referred to the IGP. So yes, there's a shared.
All right, looks like we've lost.
Sorry about that, Brenda. The DPP, I don't know whether I'm still on. Can you hear me?
Yes, I can hear you.
There's a bit of sincere apologies. There's a bit of interruption on my gadget. The DPP may direct investigations to happen, but he need not to direct investigations to happen, because the DCI has a specific constitutional and statutory mandate to investigate offences. So I think if we look at the DCI's the DPP's statement, let us look at that statement in the proper context. That the DPP was just clarifying that he did not direct that investigations do happen. That's number one. Number two, I said it would be proper that the DCI comes out clearly and clarifies the circumstances under which they raided the chambers of the two judges, because if information is flowing that is now casting doubt as to whether there were warrants of arrest or not, because to raid the private chambers of a judge, you need a warrant, a search warrant, and you need a warrant of arrest to do that. The only time you don't need a warrant of arrest is if there is a cognizable offense. In which case, then the...
Okay, Wakili, go ahead.
The only instance when the DCI can arrest is if there's a cognizable offense, a report has been made, investigation has been done, and the purpose of picking up a judge is only to require them to record a statement. Now we need DCI to clarify what triggered the arrest, because not the actual act of storming into a judge's office for purposes of arresting him may not itself be illegal per se. Mm-hmm. If there's an offense which has been investigated and there's reason to believe a judge has committed offense or someone has committed an offense, then the DCI may in fact effect arrest, even if the person to be arrested is in their chamber.
All right.
But the searching of a judge's chambers and their offices, that one for sure requires a warrant. They need to clarify that. Mm-hmm. But I think I already said this, Brenda, let us not forget the critical issue of concern, national concern. The point of issue of national concern is this. It is not that judges were arrested. No, that's not the main issue of concern. The main issue of concern and even constitutional relevance is there is a procedure for dealing with judges who may be considered to have committed an offense.
All right.
And that procedure has not been followed.
All right. So, Wakili, just from explanation,
That is the point of concern. And the procedure is, because of the sensitivity of the office of a judge if there is reason to believe that a judge has committed an offense, the proper procedure is to stagger the process. How do you get to stagger the process, Brenda? You stagger the process by filing a complaint with the Judicial Service Commission.
All right.
Then the Judicial Service Commission, yes.
So actually, you're already taking us through that, the procedure that should have been followed before the judges were, can I say, arrested or taken to the DCI offices, because they were told they've not been arrested. The only thing that's required from them is for them to write a statement, which they're not understanding why they needed to write a statement. But what we can confirm for you is what Justice Chitembwe told my colleague, Nzao Musau, who has actually written a story on let me just use the word arrest of the two judges who are taken to the DCI to record a statement. And this is what he said. He said that the officers did not come with official search warrant nor disclose the nature of their inquiry. But then when you look at the conversation that he was having with my colleague, Nzao Musau, who's written that story on the Standard newspaper, page 7, you can get a hold of that, our viewers. He says that such kind of cases actually tarnish your name. And this is not the first time that Justice Chitembwe is finding himself in this kind of a situation. When he appeared before the Judicial Service Commission trying to defend himself why he needs to be given that position of the Chief Justice, which he didn't get at the end of the day. He also, matters of corruption which was leveled against him while he served as Company Secretary of National Social Security Fund, were asked, and this is now another case of corruption being leveled against him. Then we also have Justice Muchelule, who was not been appointed by the president. Wakili?
Yes, can you hear me? Brenda, can you hear me? Sorry?
Yes, I can hear you. My question, I just have two...
Yes, please take the question again.
My question is, we are looking at these two judges who have found themselves in such an awkward situation, writing a statement on allegations that they do not know about, because that is what Justice Chitembwe has said. And this is not the first time that he is finding himself in this kind of a scenario. When he appeared before the JSC, questions about allegations of corruption when he served as the company secretary of the NSSF was asked. This is the second time again. Justice Chitembwe is finding himself again, matters, allegations to do with corruption. Then you also have Justice Muchelule, who has not been appointed by the president. He's among the judges who are not promoted. So what is really happening to these two judicial officers?
I think, Brenda, if you look at it in that context, then it's possible to say that there may be more than meets the eye in the arrest or the ongoing investigation, because Justice Aggrey Muchelule was recommended as a judge by the JSC. And I said before, I represented the Law Society of Kenya in the petition seeking to compel the appointment of all the 41 judges as they then were. Of course, some were appointed and there are 6 that still remain. There's an explanation that was preferred by State House, the Office of the President, that the judges that have not been appointed have dubious integrity. Now we have seen one of the judges who have not been appointed has subsequently been arrested. Questions can legitimately emerge whether this is the reason why he was not appointed. Now, because he's been arrested in circumstances that are not properly explained, the problem of quantification, the problem of perception is now immediate. Because now, can we now say that is it a case of the executive working backwards to justify why Justice Aggrey Muchelule was not appointed in the first place? Regarding Justice Chitembwe, he had been arrested before, investigated before on allegations of corruption. He has now been rearrested and is being investigated. I think those who claim or those who allege that there's a specific case of executive overreach, intimidation and interference with the independence of the judiciary, I think those allegations may not be entirely far-fetched.
All right.
If you look at the broader picture, Brenda, right, which is why, again, we need not to be in this place where we are now trying to imagine what went wrong or what led to the arrest. had there been proper structured communication. Remember, there's something that the DPP has been doing, which I think has not been recognized, but it adds value and it lowers anxiety. The DPP, before ordering the arrest, has been known to issue a press statement saying that investigations has been ongoing. A file has been recommended to, a file has been forwarded to me. I have reviewed the evidence and I'm satisfied that there's reason to arrest and arraign the named persons in court, and therefore I order their immediate arrest for purposes of plea taking, production in court for purpose of plea taking. It prepares the country, but you can now understand the shock reaction the nation has had when you see as breaking news, 2 judges have been arrested.
All right.
The most important question of political and constitutional relevance is this. Politically, the question that will emerge, is it a question of executive revisit on the judiciary? Constitutionally, is it a question of interference with the personal and institutional independence of the judiciary?
All right.
And I think these questions remain outstanding. My parting shot would be this. In all instances,
as we wind up
where judges, my parting shot is this. In all instances where judges are suspected to have engaged in inappropriate conduct or corruption, the procedure must be adhered to. That procedure is that any complaint relating to the office of a judge should in the first place be processed by the Judicial Service Commission. Courtesy demands in the second place that the Chief Justice, who is the head of the judiciary, be informed prior. And then a statement in the third instance be given to deal with the unintended consequences. The statement preceding an arrest of a judge is necessary because of the sensitivity, integrity, and the dignity of the office of a judge, all of which may collapse if a judge is arrested abruptly. I think let us stick to that format. Otherwise, judges must also know, and of course they do know, that they are not immune to judicial proceedings. They are not immune to criminal prosecution. The only thing we want is that let us be careful not to create an impression that we are fighting the judiciary, we are intimidating judges, and we are undermining the independence of our judiciary. Brenda.
Right. Thank you so much, Steve Ogola, a lawyer right there trying to give us an explanation on the right procedure that should have been followed yesterday and what Kenyans need to expect out of this arrest of the 2 judges. We're yet to hear from the Chief Justice, Martha Koome herself, and also from the Judicial Service Commission, and also the DCI has to come out very clear concerning what they're really investigating, because it looks like they've been thrown under the bus. We also wait to hear from the DPP again, because as of yesterday, he said he was not aware of the circumstances which led to arrest or questioning of the 2 judges. Neither has his office received any investigation files concerning the 2 judges. So, apart from that developing story, I need to take a short commercial break, but when we come back, we shall be crossing over live to the KICC that has been playing host to the IEBC selection panel for the last 2 weeks when it comes to interviewing of the 36 candidates that were shortlisted for the